Good morning. Are you Paul Nelson?
Yes, sir.
And will your client waive the formal reading of the indictment in each of the cases?
Yes, sir.
Mr. Nelson, in cause number 23 DCCR 1786, you're charged with the third-degree felony offense of possession of from January 13th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
And then in cause number 23 DCCR 1787, you are also charged with the third-degree felony offense of possession of from January 13th of 2021. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with your attorney?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone.
Yeah.
State, excuse me. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Nelson is not competent?
None, Judge.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. And at this time, in cause number 23, DCCR 1786, find you guilty, sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 23, DCCR 1787, find sufficient evidence to find you guilty, and at this time find you guilty of possession of sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time, and also concurrently with the Montgomery County cases. Is that correct?
Right.
They'll run concurrently with that as well. I'm handing you the trial court certifications. Those show that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Judge Walker. All right, good luck to you, sir. You can go back to the bailiff. Yes, sure.
We would ask that the court waive any court costs as he has indigent. If I need to, if the court needs me to inquire about that, I'm happy to, but he's been incarcerated for 2.5 years and he has zero dinero.
What are the typical court costs on a?
$200 and something plus this fee plus that fee. So total in both cases, Your Honor, will be around $550.
What I'll do, let me make a notation and I'll get with Ms. Werner, the other clerk, and find out exactly with a process for that, and take into consideration that he's indigent, that you've relayed that, and I will let you know exactly how that works and if we can do it. Do you have any issue with regard to that?
I'll defer to the court on that issue.
Okay, thanks, Ms. French. All right, you can go back with the bailiff. Yes, sir.
Have a good day.
You'll make a note for me on that, please. Good morning, sir. You Jabbar Alexander Bell.
Good, thanks.
And Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
Excuse me while I get my file piece.
Okay, we're going on. Let's see. Let me.
And then walk away. What you found is police.
Would we're going on all of the counts, it looks like.
Yes, to enhance.
To a third. It's gonna take me a second.
But not.
I'll figure it out. Mr. Bell, in cause number 26, DCCR 0139, you're charged with the state jail felony offense of theft of property with previous convictions from September 25th of 2025. The indictment alleges you were previously convicted of theft May 18th of 2018 in 2 cases, and then after that was final December 3rd of 2021. And then the indictment further alleges that you were previously convicted of the state jail felony offense of unauthorized use of a vehicle June 24th of 2019. And after that was final, you were convicted of evading arrest or detention with previous convictions, a state jail felony November 8th of 2021. And after that was final, you were convicted of burglary of a building, a state jail felony June 26th of 2023. And how do you plead to that charge?
Guilty.
And are those all of those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
We next to the bank. Action. And I think.
Okay, and then we have clause number 26 DCCR 0140. And, sorry, just a minute. And in that case, you're also charged with the state jail felony offense of theft of property with previous convictions. And that one is from December 16th of 2025. The indictment alleges the same prior theft offenses, the 2 from May 18th of 2018, and then the last one from December 3rd of 2021. And then it also alleges those same prior 3 state jail felony convictions. And how do you plead in that case?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are those prior convictions all true?
Yes, ma'am.
Shh. And then finally, we have 26 DCCR 0274. And you are charged in that case with evading arrest or detention with previous convictions from January 21st of 2026. It alleges that you were previously convicted of evading arrest or detention March 13th of 2017 and also November 8th of 2021. So this one does not list those other priors. So it just is a state jail.
It's supposed to.
And I apologize, I didn't notice that it didn't list the other priors.
We don't object to an amendment if they.
Now, the state would ask to amend.
I'm not writing all that in.
Okay. You want to dismiss that one?
I mean,
That is the,
evading arrest or detention with previous convictions.
gosh, I hate dismissing and evading.
I mean, I can reset it. Y'all can file an amendment, or if you want to write it out, but that's too much for just an amendment. That's 3 prior
Okay.
offenses. So whatever y'all want to do. Y'all want to talk about it for a minute.
I can write them out if I need to be consistent.
Why don't you do either handwritten or typewritten if you want to get down here real quick, a notice of to enhance with those 3 in it. And then I can read the enhanced, the notice to enhance.
Okay, I'll do
Okay.
that very quickly.
I'll hold it.
Thank you.
All right, are you Jameldrin Willridge? And so before we go forward, Mr. Lewis and Ms. Malfino approached about possible solutions to the issues that we have here with Mr. Wilridge is on probation. In 3 cases, there was a new offense that occurred while he was on probation, but before he went to ISF as a part of that probation. And what I want to know before I consider any type of continuation of probation is couple, I guess, number one, how do you have any idea how he did, Mr. Kitchen? I guess, and before you go forward, would you raise your right hand? You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
Any issues with regard to behavior at ISF that you were aware of?
None that I'm aware of.
Okay. When did he get back from ISF?
I'm not sure exactly. I did not receive Mr. Woolridge under my supervision until September 26th of last year.
Okay. And how has he done from then until he was incarcerated on this?
And he was very cordial with me. We've had cordial bits of surprise by this and the other stuff that's been going on with it.
Okay. Any positive drug screens, any issues at all since you had them in September? Okay.
May I just ask him one question for the clerk?
Of course, please.
Mr. Kitchens, you brought to my attention, and I think the clerk has also sent it to Mr. Lewis and myself. His behavior in jail is less than to be desired, correct?
Yes, that's correct.
And would you characterize that as his association with those individuals who the court is very well aware are in jail, that is a different side of him than you saw while he was out on probation under the guidance and eye of the court and his family?
That's correct. Yes.
With the understanding, I'm sorry, Judge, if I may, that obviously Mr. Wilders is facing quite a bit of time from this court on a revocation. And would it be your intention, along with the court and myself, to make it clear to him that if he is given this opportunity, that if he comes back before this court, that he's not looking at maybe what he would be looking at today, but probably 3 times in advance of that amount of time?
Yes.
And do you think he is capable of and understands the seriousness of what it is he's facing
I believe he does. Yes.
from your interaction with him?
Okay. Well, Mr. Wilridge, this is tough for me because you've been given a couple of opportunities and this would be another opportunity. And I don't know. I don't want you back in here. I don't want you to violate. I want you to be successful. You've been on a decent path. But what you did and thought you got away with, things catch up with you. Right. And so that one's a 2 to 20 case. I could revoke you on your ag robbery and send you to prison for the rest of your life today. The rest of your life. And based on the history and what's been going on, some big fat number is probably what you deserve. And so I don't know how to be any more clear than if I give you this opportunity with what your attorney is working out with the district attorney, that Mr. Kitchen sounds like he's willing to work with you. And if I go along with this and leave you on probation and put you on a new probation, if you're back in front of me, there will be absolutely no argument about continuing probation or some low end of the punishment range. That won't be what's happening. Do you understand?
Mm-hmm.
You're going to be on 0 tolerance. That means no mistakes on probation. You've been on it long enough now to know how to be successful or not on probation. And if you just live your life right and do what you're supposed to, that shouldn't be a problem. It's only hard if you're doing the wrong things. Does that make sense?
Yes.
All right, y'all can do the paperwork.
Thank you, Judge.
Thank you.
All right, again, you are Jameldrin Wilridge, correct? Speak up for me.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She does, Judge.
Find it now. Mr. Wilridge, in clause number 25, DCCR 1804, you're charged with the second-degree felony offense of burglary of a habitation from August 29th of 2024. And how do you plead to that charge?
Be guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow this agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And the agreement shows that this is for a 10-year deferred probation. What about, this is the one with the shoot. What about restitution? Right? This is the one where he went,
Yes,
it's all the shoot.
It was 100,
It was a lot.
probably 100 pair of Jordans. You would think I would know how much those cost.
So here's what I might do, just so that I have everything that I need. Go ahead and get a pre-sentence report.
Okay.
You can get with them, get
Yes,
a restitution amount. You are going to be required to pay restitution. So if you still have some of the shoes, find them, get them, talk with Mr. Lewis. They can be returned, so you don't have to pay for them.
Okay.
He did get it all back?
I'll confirm
Okay.
that. You're
So we're going to just get that confirmed between now and then. And I do want to go ahead and kind of get an update so that the new case is in a PSI, since we don't have it, the new case. I don't need a little update on the probations, for sure, double check on ISF and how that went, but it sounds like there's not an issue, but I just want to make sure. And so, do you also understand, Mr. Woolridge, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Your.
It's admitted. Is there any evidence Mr. Woolridge is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can just have everything in front of me that I need, make sure there's no other issues, and then we'll go forward with sentencing at that time. Any issue with me releasing Mr. Woolridge since he has been doing okay?
No, Judge, if only if wouldn't mind if I just hold on those MTRP dismissals until that sentence
Yeah,
date.
I
just
think
in
that's
case
what
something
makes sense.
pops up.
I think that makes sense. So, Mr. Woolridge, what I'm going to do in your case is reduce your bond to $1,000, but I'm going to make that a personal bond. What that means is that you don't have to pay the money. You will be released today. So what I need to do, though, is on those motions,
Unless it would make it easier for you if I just dismiss
just
it.
do personal. I can just set personal bonds on all of them. So I'm going to set personal. So on all 3 cause numbers that you're on probation for, which is 18-28743, 18-28744, and 18-30139. I'm going to set bonds on all of those where the motion to revoke are pending at $1,000 also, and make those personal bonds. So what all of this means is that you're going to get out today without paying any money. Some very, very important things, though, between now and when you come back for sentencing. Obviously, you're on probation still for the other 3. You need to report to probation for 2 things. 1, because you're still on probation. 2, so that they can do that updated pre-sentence report about the new case and kind of how things are going right now. Okay. If you don't go straight to probation when you're released to do all of that, then you run the risk of me not accepting this plea agreement. Things could obviously be much worse. You understand? Speak up, please.
Yes, ma'am.
Also, if you're arrested for anything between now and when you come back, you run the risk of me not accepting this plea agreement, and then you've got those motions pending, and things could obviously be a whole lot worse. You understand that as well? And so, was there a co-defendant in the burglary? Or no? Okay.
I don't think so.
So you do, I am going to order as a condition of your bond also, and it will be a condition of your probation that you have absolutely no contact or communication with Jasmine Adams as the owner of that apartment. And that apartment was where? Do we have an address?
That apartment was located
I can probably get that.
at 4165 Old Dallin Road. It was apartment 91, but I would suggest
So,
you stay
yeah,
away from
so-
the entire complex.
Correct. That's what I'm gonna do. So you cannot go anywhere near 4165 Old Dallin Road. Any of it, none of the apartments. Do you understand?
Yes.
Anything else that you feel like I need to, order as a condition of the bonds?
I'm just double checking for any type of co-defendant. No, Your Honor, I don't believe so.
Okay. All right, then we'll see you back at sentencing. Again, make sure as soon as you're let out of custody that you go straight to probation. Okay. Good morning. Are you Lloyd Calhoun? And Mr. Parker, will your client waive the formal reading of the indictment?
Hey, the judge.
And we're just going in the possession case, is that correct?
That's correct, Judge, but on the, with the prior enhancement counts to make this a third degree and just so to be candid with the court, in 2019, he also received a 5-year sentence. This same 5-year offer was made based on the underlying facts of this offense.
Okay.
What he did was pour some PCP out on the floorboard carpet of the car, which made it difficult to measure the quantification.
Okay. All right, Mr. Calhoun, in cause number 25, DCCR 1266, you're charged with the state jail felony offense of possession of a controlled substance from April 14th of 2025. And how do you plead to that charge?
Yes.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Listen.
That indictment further alleges that you were previously convicted of unauthorized use of a motor vehicle, a third-degree felony, May 17th of 1993. After that was final, you were convicted of possession of a controlled substance, a third-degree felony, June 3rd of 2002. And then after that, you were convicted of unlawful possession of a firearm by a felon, July 8th of 2019. And are all three of those prior convictions true?
Mhm.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? He went over those with you? Do you fully understand those documents?
Some of them.
What do you not understand?
I gotta look at it to see it again, but most of them I do.
Well, let me go over a little bit more with you. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow this agreement, you can't change your mind later,
Yeah.
right? And it looks like the agreement's for 5 years in prison with a dismissal in clause number 25 DCCR 1267, which is that tampering case.
Yes.
Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Back time?
Yes.
No.
Just the time that we've had a hold on you here. So I don't know if you are serving time anywhere else or were anywhere else. Okay. So you'll get that credit. I'm going to, is it not printing? Okay. I'm going to hand you in just a minute a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You're also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. You already know this because I know you have a history with a charge of this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And then I will sign a dismissal as soon as it comes through in clause number 25, DCCR 1267.
So then it's out.
You put the holes.
Well,
I think I probably printed it twice at least.
and this is, what I printed stuff for Pam a while ago, and what I gave her wasn't all of it. Apparently we ran out of paper, but I didn't know.
I printed some stuff also from that other case.
Okay,
I printed one for me, several things for myself.
well, I think it's something.
Okay, all right. Here you go. You can go back with the bailiff.
Look, yeah.